All right. Thank you so much for joining us today and for being here with us during your lunch hour or whatever hour it is for you. We should be here until about 1. I just have a few kind of rules of the road to go over first. Since we're in webinar mode, we cannot see you or hear you, but we do know you're out there and we welcome your questions and comments. You can go ahead and put those all into the chat box and we'll get to as many of your questions as we possibly can. If your questions are a little bit more personalized, we will suggest that you go ahead and contact Jennifer or Consolidated Planning Group outside of this so that, we're not taking up time with too many specialized questions that only apply to you. But we are recording today's webinar. Later today, you'll get a copy to the link for the recording, and you will also get a copy of all the slides. And anything that is clickable, you'll be able to click on that later on today, even though you can't do it during the webinar. So first of all, a huge thank you to Ms. Tawana Smith for hosting us today. Do you want to tell us where you're from?
Good. Can you hear me?
Yes.
Oh, hello, everyone. Glad to see you. Glad you're here for this great information. My name is Tawana Smith. I'm a student hireability navigator for the Central Texas area. I cover Region 3 for VR, Region 3 for Central Texas Workforce Board. I also cover Region 6 and 3 for the Vocational Rehabilitation Services. I love putting these together to make sure y'all get good information, the right information. It's a pleasure. If you have any questions or comments for my area, I will put my information in the chat box so that you're able to reach out to me if you have any concerns or how to get in contact with Vocational Rehabilitation Services for kids from 14 to 21. And welcome, everyone.
Thank you so much, Tawana. So I have a couple of slides to go through myself before we introduce the main attraction today, Miss Jennifer Swanson. But today we're going to be talking about guardianship and the things that you need to consider. Consolidated Planning Group is a holistic financial planning firm that focuses on special needs planning. We're located just outside of Houston. We work all across Texas and all across the United States. So we've been doing this for about 30 years. And the owner of the company, she has 2 special needs daughters, and that's why we do what we do in terms of educating and advocating for families with loved ones who have some kind of an intellectual or developmental disability. We are fully licensed in insurance and securities, members of the Special Needs Planning Academy, and certified nationally as Social Security advisors. So we can help you with all of your needs when it comes to financial services. On the next slide, it goes over a little bit about why families come to us. They're looking for protection plans, how to take care of their family, a lifetime of care, how to plan and prepare for transitioning to adulthood, ABLE accounts, we do a lot of those, and just advocating for families, like I mentioned. There are over 263,000 financial advisors across the United States, but only 0.1% of those advisors, so like fewer than 260 financial advisors across the United States, focus on special needs planning like we do. So you are definitely in the right place. Next slide. I think I have one more. Yes. So things that you need to think about when you're talking about what we do as special needs planners. Developing that future care plan so that you can answer questions like, who is going to take care of my child? How am I going to pay for that? How am I going to enjoy my retirement and also set aside enough money for my child's care? We help people consider options beyond high school. You know, what is there in terms of educational options, vocational options, transition programs, day programs, even residential communities. Waiting lists can be long, so you want to plan early for those things. And we want to make sure that parents carefully consider this decision before they just say, oh, well, we're just going to let a sibling take care of our child once they grow up or once we're gone. You know, it can be the right answer for some, but it's not right for everybody. So today we're bringing in Jennifer. Miss Jennifer Swanson is an attorney. She is going to take over and talk to us today about guardianship, which we get a whole lot of questions about. And we always tell people, you need an attorney, you need someone who specializes in this very specialized area to be able to help you out. And so one of the attorneys that we trust, Jennifer, is here with us today. So thank you so much. And you are, there you go.
Thank you. Sorry, I had to unmute myself. Thank you so much, Michelle. So just a quick little blurb about my background to understand how I came to the practice of law and what I do as an attorney. Prior to going to law school, I was actually a special education teacher in Texas. So I worked with elementary age children with disabilities, ranging from a life skills classroom through resource. And that was the beginning. That was my first career. That was 9 years. Then I went to law school. And now I practice primarily special education law, working with children and parents of children with disability, special needs, IEP plans, Section 504 plans, to navigate the system, to work with their school districts, to be able to get their free, appropriate public education. I also do guardianships because naturally our kids become adults, and it's a normal segue. So the reason that that's important is that's how we're approaching guardianship today. If you've been on CPG's YouTube channel, they have talked to multiple guardianship attorneys. And so they've gone through the ins and outs of guardianship. We're going to touch on some of that. But what we're looking at today, if I can make my slides work, is how to decide actually whether guardianship is the right decision for your child, soon to be adult. So I want to stop here and just sort of preface with, there's a saying that the best time to plant a tree is 20 years ago or today. So if you're coming to this webinar and your child is about to turn 18 and you feel like you should have, could have, would have, let that go for a little while, because there's nothing that can't be fixed with the right time and the right professionals. I want to encourage you to enjoy this webinar from a different perspective, looking at guardianship with the overlap of special education and how special education can inform and help you make that decision about whether guardianship, supported decision-making, or just good old-fashioned turning 18 adulthood is what makes sense. Okay, so let's start with their 18th birthday. Let's start at 18. There are really just 3 options for any individual who's turning 18. The first is adulthood. You turn 18, this is your transfer. This is when the rights transfer. All the rights that you've had from the day they were born until the day before their birthday, they go to them. Their right to vote, their right to marry, their right to fill in the blank. You will be made aware of this if your child has an IEP. Or 504, there's a requirement to let parents know about the transfer of rights, that it's coming, especially because a lot of our students will turn 18 before they graduate from high school. So they will technically be adults still in public school, right? So that's adulthood. So then in the middle, a little more, not really restrictive, but a little more support is adulthood with supported decision-making. So the rights still transfer, but in this situation, you and your now adult child have developed a plan. A supported decision-making agreement has been signed along with other planning documents, and we'll talk about that. A supported decision-making agreement really shouldn't be used in isolation. It should be used with other documents. And so that's kind of the middle of the road. And then there's guardianship. And guardianship is the most restrictive. Guardianship requires you to go to court. You cannot file this online. This is not something you can just sort of do passively. You have to actually sue your child, and it sounds worse than it is, but you are literally suing your child for their adult rights and asking the court to strip them of their rights and give them to you. All of which sounds terrible. Guardianship is not a bad thing when it's necessary. Okay, it's a good thing. But that's what happens. The court takes away those rights and gives them back to you. And then you become their guardian and they become your ward. Okay, and those are some terms that we use. So that's an overview. That's what happens at 18, right? So how do I know which path to take? How do I know what's going to make the most sense for my child? In some situations, you don't need someone to tell you. You know that your adult child is able to go off to college, is able to go and do, or go to the military or start working or whatever their life plan is, they can just go straight into it. And that's that. On the other end of that spectrum, your child has some challenges. Maybe at this point, they're nonverbal, they have personal care needs that they can't take care of themselves. And you just know that they're not going to be able to be, independent in any capacity. But it's the middle of the road, right? That's where we are unsure. My child has a lot of strengths. They're able to do this. They've achieved so much, but I still worry about X, Y, Z. So how do I know if I should pursue guardianship or work on supported decision-making? So not to be frustrating, but let's go back. Let's go back to the beginning of school and just talk really about the IEP. And this is where the integration comes in. And I promise that it'll make sense. So in the interest of not messing up the slide, I'm going to read to you from my phone. I love the Individuals with Disabilities Education Act. I love the idea of it. Prior to it being signed, and it was called something different, children with disabilities in this country were not allowed to go to public school. So I'm going to read to you, this is part of the law that nobody looks at really, but so the finding, okay? Congress finds that disability is a natural part of the human experience and in no way diminishes the right of the individuals to participate in or contribute to society. So improving educational results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. That is what Congress found when they were drafting, lots of reiterations, but let's just say drafting the IDEA. So the purpose of the IDEA, which governs IEPs, is to ensure that all children with disabilities have available a free, appropriate public education with special education and related services to meet their unique needs and prepare them for future education, employment, and independent living. Okay, so this is why special education segues into guardianship and supported decision-making. Okay, so let's kind of get into the weeds about one particular aspect of special education. IEPs and transition planning. So if your child has an IEP, if you were in elementary school, I can remember being a teacher and we would have parents come in and their kids are in kindergarten. We'd go through our agenda and we get to transition planning and we'd say, oh, mom, dad, they're in kindergarten. It's too early to worry about transition planning. I disagree with that. I think transition planning starts the day they start school. We start to look at their strengths and their interests and we encourage them. We make sure that we make the most of their education and their time and their childhood. But in Texas, specifically, transition services don't start until a child is 16, unless they have autism, and then it starts at 14. And that's when you'll start to look at those sections of an IEP. So this is from the regulations, and I'm just going to go over the highlighted portion to talk about what transition services are. They're a coordinated set of activities that are results oriented, that facilitate the child's movement from school to post-school activities. And those post-school activities are post-secondary education, vocational education, integrated employment, meaning supported employment, continuing and adult ed, adult services, independent living, and community participation. So it covers a range, right? It's whatever they're going to do after they are graduated from and released from public school. That's the purpose of a transition plan and those services, is to prepare them for that. Okay, so let's look a little more deeply. And I think Michelle said it. If you have specific questions, don't hesitate. Sometimes it's hard to go back and remember what your question was. So please put it in the chat. So this is from the TEA website. I put the link at the bottom if you want to go in there and look. These resources are available online. This is nothing prioritary. I said that wrong. This is nothing from my law firm. This is from the Texas Education website. I apologize.
Proprietary.
Thank you. Oh, it feels like a Monday, doesn't it?
Oh, yeah.
Thank you. So this is a guide, right? A secondary transition guide for parents. And this is just one excerpt from it, but it lists basically the same things that we read before. But I show you this to basically to let you know there are guides online if you want to go ahead and have a look at them. But it again goes through the list of different things we could be preparing our child for. Okay. It's not intended to be a one size fits all, as IEPs are not intended to be a one size fits all, right? So post-secondary education to community participation, which could be day hap, it could be volunteering, it could be a combination of continuing education and internships, supported working in a supported environment, all those sorts of opportunities. Okay.
Now, Jennifer, we do have one question. Wendy thought that transition plans had to be in place before the child turns 14. Is that not the case?
Well, I guess I don't understand the question. So they don't have to be 14 is the number if you have autism. We start planning for transition earlier. 16 is the have to date. But that's why I was saying it doesn't hurt. It's actually a good idea to start thinking about it sooner. But a lot of our committees won't begin to plan until they're legally required to do it, if that makes sense. Did that answer the question?
I think that makes sense to me. Does it vary by different state?
It can. It absolutely can. And I'm only licensed in Texas. So that's very possible. So and you know what, that's actually a really good point, Michelle. I should have said this at the beginning. None of this is specific legal advice. This is a guide for helping you decide which route to go. So don't take any of this and think that your IEP is wrong or your plan is wrong. You need to talk to a professional if you're having issues with your school district or if you just have questions. And if you're in a different state from me, by all means, check with your local education agency. Sometimes it's called the Department of Ed. But yeah, absolutely. So it can be, some of these things can vary from state to state. It's a very good point.
Thank you.
So as early as possible, schools should begin developing programs and services based on students' strengths, preferences, and interests that focus on instruction, related services, community experiences, and development of employment and other post-school adult living objectives, daily living skills, functional evaluation, if necessary. So again, these are just broad ideas. You would look at your own individual child. What are their strengths? Okay, you have a student who's really great at math. They really love crunching numbers. They headed the finance route. You want to encourage those things. Get them an internship with CPG. I'm just kidding. Get them an internship, get them those opportunities. You have a student who wants to bake, who enjoys baking, would like to see if working in a bakery would work for them. But they're not going to be able to drive. So what kind of instruction do they need? Well, they're going to need travel training, right? They're going to need to learn how to read bus schedules, take the bus, make it to the bus on time, have the correct bus fare, all those sorts of things, if public transportation is available to them, right? And those are just some examples, but that's what a transition plan is going to look at. We look at what we think the end goal will be, and we give them those tools and training opportunities in the interim. So how do transition plans relate to supported decision-making or guardianship? Okay, so let's take a quick look at guardianship and supported decision-making. So this is from a different part of the law. This is the Texas Estates Code. Okay, and I've got these sections highlighted. So when you are applying for guardianship, and that's what it's called, application for appointment of guardianship. The document that you file with the court is an application. You have to look, these are some things that are required to be in the application, but of importance are 3A and 3B, importance for our discussion today. Whether alternatives to guardianship and available supports and services to avoid guardianship were considered. You have to present that to the court when you're applying, and whether any alternatives to guardianship and supports and services available to the proposed award are considered feasible and would avoid a need for a guardianship. So the example here is, let's say that your student has a lot of strengths. They can travel within the city independently. They hold on a job at a bakery. They are able to take themselves out socially. There's a lot of strengths, but they're not doing really great with their money. Money's hard. Money's difficult. It's hard to budget. It's hard to know how much to put aside. That's difficult. Do you need a guardianship for this student, this child, this adult child, because they can't manage their money? Well, maybe not, right? Probably not. And in this scenario, a person who can be that independent likely doesn't need a guardianship, but they do need a support or a service. So what are those alternatives to guardianship? Okay, this is, again, from the code. This is a list. It's not exhaustive, meaning there could be other things, but these are the ones that the legislature specifically parsed out and put in the code. So these are some potential alternatives to guardianship: a medical power of attorney, a durable power of attorney, a declaration for mental health treatment, an appointment of a representative payee to manage public benefits, establishment of a joint bank account, a management trust, a special needs trust, a designation of a guardian before the need arises, or establishment of alternative forms of decision-making based on person-centered planning, which is a catch-all phrase for anything else the legislature didn't think of that is available or could potentially be available in the future, right? So there's the list. So let's connect the dots. So let's finally, we've been in class all morning, nerding out on the IDEA and the state's code. Let's talk about how they overlap, right? So here's my example. We have a durable power of attorney. Okay, it allows the agent, that's the person that is chosen to handle the matters, to handle financial matters. Not healthcare matters, not educational matters, just financial matters. Okay. So then, and I'm sorry, I got to move my box of myself out of my way. In transition planning, we have, as I mentioned before, job coaching. Okay. We have travel training, interviewing skills, resume drafting. So all of these things that you and your ARD committee have painstakingly worked on with your then child, soon to be adult, to get them ready so they can navigate the city. They can make it to their job on time. They can work out conflict with peers in the bakery. I'm upset because they're at my station. I have conflict resolution skills because I was given X number of instruction. So I have all of these abilities, but I struggle with paying my bills, budgeting, maybe adding and subtracting. Maybe that's not the skill that I was able to develop. So a durable power of attorney given to a trusted loved one, a mom, a dad, an aunt, an uncle, etc., could avoid the guardianship because they're otherwise independent. Okay, so this is an example of an alternative to guardianship. Okay. Any questions so far? Nothing?
I don't see anything else coming through yet, but I'll let you know when something comes up.
No big deal. No big deal. I just want to stop because sometimes I feel like I switch gears, but it's important to show how it overlaps. So how do supported decision-making agreements and least restrictive alternatives and supports work together? So a little asterisk here. If you're in the IDEA world, you're familiar with least restrictive environment as a legal term of art that describes students' supports and services. Least restrictive alternatives comes from the estates code, and it describes that laundry list, the 9 items that we went over before. So how do they work together? So let's talk about supported decision-making, because I alluded to earlier, if you go the supported decision-making route, I don't think it should be used in isolation. I think it should be used with other documents. Perhaps some of those least restrictive alternatives we described, or some other legal options, all of which are going to be very specific to you, and you're going to want to talk to a practitioner about it before you make those decisions. But supported decision making from the code is a process of supporting and accommodating an adult with a disability to enable the adult to make those life decisions. So the wording here is important, okay? To support, to accommodate, to enable, without impeding the self-determination of the adult. So I think it's really important to just stop here and talk to, and I don't want this to sound pejorative, to the parents who have taken care of this child for years, who have looked out for them, looked out for their best, made sure that they had the best of everything. It's a difficult transition when I talk to parents whose kids are turning 18. Supported decision-making does not give you the right to make decisions for them. And it doesn't have any kind of leverage. So if they sign a document, a supported decision-making, and then decide they want out of it, that's it. They're out of it. It's not binding on the individual with a disability, or on you as the supported decision maker. It's not binding on either of you. The purpose is to create a construct, to create a conversation, to rally the community, to help this individual live as independently as possible, and to continue to have self-determination. So the agreement is just an agreement. It is, a lot of times we formalize it on paper, of course, but it is an agreement between an adult with a disability and their supporter to work together. Okay, so on this next page, the Texas has a form. You can get it offline for free. You don't need someone to get it for you. And this is just an excerpt of it. You don't have to use the Texas form. You could create your own form, but the form exists. And I'm going to show you this section specifically because it helps to understand how the agreement should work. It's a conversation. Mom, dad, supporter, I want you to help me to figure out where about my physical health. I don't like going to the doctor. I'm not sure what those words mean. I know, and I want your help with that because that's something that I need help with. But I don't want your help managing my money. I'm an adult and I can do that. Okay. Or I really just need you to help me choose and maintain my services and supports, or other. Okay, it's customizable, and it should be based on the individual, and it should be a conversation. And in my opinion, it's something that should be discussed well before they turn 18. Okay, you should be, I don't, should is not the right word. It's advisable to start this conversation early, to sit down with your child and say, one day you're going to turn 18 and you're going to have to make these decisions. And here's an opportunity for you to keep me, to allow me to continue to help you, but I won't get to make the decisions for you. And if you a lot of times have those conversations earlier, I think the process goes better, because adulthood is exciting. It's terrifying, but it's also exciting, right? And I think if any of us, with or without a disability, are completely honest, at 18, pretty much all of us still need support, right? So this is a good way to start the conversation. Well, this is a good way to formalize the conversation that you hopefully started earlier. Okay. I am going to actually go back. I'll stay on this screen. So I don't believe I have a slide for this. I may have one later, but I'm going to go ahead and unpack it here because I think it makes the most sense. When I say that it shouldn't be used in isolation, it's because I can say, I want you to come with me to my doctor's appointments and help me understand what's going on there. But once I turn 18, no one has the right to my medical records except for me. Okay. So if my supporter is going to help me, they probably need to have access to my medical records. So that's a different form. That's a HIPAA release that allows them to have access to your medical records and in some cases talk to your providers, right? So that's a form you would want to put with this as an example. There are others, there are various powers of attorney that can look at obviously financial matters. We kind of covered that one. There are health directives, living directives, right? If I become ill and incapacitated, I want the doctor to do X, Y, Z. Okay, there are, and again, there's a ton of other ones. And finding the right form, the right forms and different options is going to be highly specific to you. Supported decision-making is more like a hub. Think of it as a hub, and then we have the different documents that we need to support what we want from our supporters, if that makes sense. Okay, so continuing to connect the dots, you've seen this screen before. These are some of the things that secondary transition, this is when we're in public school, are supposed to do: post-secondary education, vocational, adult services, all those sorts of things. And so how do they connect? Okay, let's go back to our example from before about I want to work in a bakery and I am independent and can do XYZ. I need help with my finances. Okay. If we go back to public school, if we go back a couple of years before we get to 18, beginning to look at transition helps us to plan for those things. Okay. And so we have to plan from the top down. If your student knows they want to work in a bakery, what kind of skills do they need to work in a bakery? They need to understand health and safety, hygiene, right? We need to be able to wash our hands. If we have sensory issues, we need to understand that we may have to wear gloves. We may have to wear other types of clothing to hold our hair back. I mean, there's a lot of, there could be some sensory issues there. I remember, I don't have sensory issues, but I remember when I went to college, my first job was in food service and I did not like the hairnet. So, you know, and I don't have sensory issues. There may be conflict resolution issues. Do they have difficulty working with other peers? Are there noise issues? So there's a lot there. There's a lot there that you could work on ahead of time before getting to that point. So the next topic that I want to go through is a little bit more of a delineation between guardianship and supported decision-making. One of the things that you really need your student to be able to do is to be able to basically sign a contract. Now, that doesn't mean to be able to physically sign it. If you hand your child the supported decision-making document and they're able to talk to you about what they want and what they don't want, then it's likely possible that supported decision-making makes sense. But if they're going to sign a document because you told them to sign it, and they don't really understand it and they can't explain it to you, then I would say you want to talk to a professional a little bit more to find out whether supported decision-making is appropriate. Another thing that parents will suggest, though, is you can start with supported decision-making, and if it's not effective, you can always go to guardianship, right? Move from the least restrictive to the more restrictive, and that's an option depending on your specific circumstance.
Jennifer, can you talk a little bit about the costs associated with guardianship and the other options there are?
Absolutely. So supported decision-making really shouldn't cost anything unless for some reason you need to seek legal advice, a consultation, or work with an attorney. If you have a specific legal question about one of the alternatives to guardianship that you can't either figure out on your own, or for some reason you need to work with them, that's going to be a consultation or the cost of working with that attorney. Guardianship is going to be in a range. Okay. And so I cannot tell you what every guardianship attorney charges. There's a lot of nuance there. I think you're looking at anywhere between $2,000 to $6,000, depending on the county that you're in, the complexity of your case, whether your guardianship is going to be uncontested or contested. And uncontested just means that no one is going to come in and say, no, I think I should be the guardian, or I think someone else should be the guardian. Where that happens a lot are in cases, I think a lot where people are older and have more assets. And that's where you see a lot of people contesting. For me, as an attorney, I mostly do uncontested. And what that usually looks like is mom and dad have a child who's about to turn 18, mom and dad become co-guardians of the 18-year-old, right? And those are typically not contested. So you have the cost of paying your attorney, and then there are some associated court costs. So there's the cost of filing. In Harris County, it's around $350. Every single county in Texas is going to be different, though. So you can't take these numbers to heart. Then there's the cost of paying the attorney ad litem. You have an attorney for the applicants. Your proposed ward also needs an attorney, so the court appoints one, and that attorney is called an attorney ad litem. Unless you are able to file for indigency, you will have to pay that attorney's fees too, and that's a range of $400 to $800. Again, county specific, depends on the attorney's years of experience. you will have to register with the JBCC website, which is they govern guardianships. That doesn't cost anything, but it's a task you have to do. And then a lot of time, the counties will require you to post bond. So, and this is a huge variation. I've had bonds as low as $25 per guardian. And then I've had others who had to post much, much higher bonds that weren't just cash bonds. They had to go to like a bondsman or something, something different. And those are completely county specific. So you're going to want to talk to an attorney in your county or someone who practices in your county. And then once your guardianship is granted, you'll need letters of guardianship, and they're typically $5 to $10 per letter, and you have to get them reissued every year. You don't have to you don't have to redo your guardianship every year, but you need updated letters every year around the time that you file your annual report, which you're required to file with the court. So I think I gave you a little more information than just costs, but
that's good. That's good information, and to know what to expect. Now, as we're talking about the cost, I know that a lot of people, especially you're trying to pay for all these kids, and plus you have another child who has a special need, and where is all this money going to come from? There are certain areas around here that do a lower cost guardianship, right? Like the Arc of the Capitol in Austin, and then also in Galveston. Is that right? Do you know of any others?
I don't. I was going to say Galveston for sure. No, I mostly practice near Harris County. Now that we're out of the pandemic, a lot of courts are back in person. And so it's not really cost effective to pay an attorney who's too far away from your county, because you're going to have to pay travel costs. So I'm mostly familiar with Harris and Fort Bend.
Okay. So let's talk about different types of guardianships. There's really guardianship and then alternatives, right? They're not different types of guardianship, but.
Well, no, there are, I guess they're types. So there's guardian of the person that just looks at having guardian of the person. So in the example that I used, uncontested guardianships with kiddos turning 18, most of those 18-year-olds don't have an estate. So you would just be looking at their person, but you could also have a guardianship of an estate. Like I said, you kind of see this with more elderly individuals who need guardianship, who also have a estate. You have to look after their person and their money. So that's two different types of guardianship. You can also have partial guardianships. You can also parse out different rights. So when you are filing for guardianship, you enumerate the rights that you're asking the court to take away. And like, for instance, one of them is the right to vote. One is the right to own a firearm, the right to choose your place of residence. So you, depending on the court and the individual facts, you can have a partial guardianship where you only remove certain number of rights. I don't know how common those are, but it's possible.
Okay, very cool. We still have some time, so if you have more questions, please put them in the chat box. I'll go through a couple more slides for Consolidated Planning Group, but we're still here. We have until 1 o'clock, so put your questions in the chat and we will get to those. So if you want to go to the next slide, Jennifer.
Yes, ma'am.
So this is a list of, we do webinars 3, 4 more times, sometimes it's even more than that per week. And we are always here to help and give information and to educate. And so these are some of the topics that we've gone over and that we continue to go over in our webinars. How to develop a comprehensive special needs care plan. What do those future care cost estimates look like? And we base it depending on, what level of care your child needs. We help people with the Texas waiver programs and making sure you're on those wait lists. Sometimes those wait lists can be as long as 17 years. So definitely get on those as soon as possible if you're not already on a wait list. We help people sign up for ABLE accounts. We help people understand beneficiary designations. You never, ever want to list a special needs child as a beneficiary on life insurance or investments or your bank account, anything where that money would be left to them, because that could take away their other benefits that they could be getting, like through SSI or the waivers, Medicaid, things like that. Special needs trusts. This is another area where we need an attorney like Jennifer to help us out. A special needs trust is one place where you can have money that won't count against your child for their benefits. A special note is that if child support is something in your life, and that child support is going to continue beyond age 18, it needs to be redirected to a first party special needs trust. Let's see, residential living communities. Again, there could be waiting lists, and the residential communities, some of them have restrictions on who they can take and what disorders, or, your child has to be able to toilet and transfer themselves, or, whatever rules they have. You want to find out about those things ahead of time, find out how much they cost, and then make a decision, but still give yourself plenty of time to wait, because there could be that waiting list. Of course, today we've spent the day talking about guardianship and alternatives to guardianship, power of attorneys, healthcare power of attorneys. The guardianship process can begin when you are within 6 months of your child's 18th birthday. And it is very, very important because of the nuances and the special things you need to know. You don't want to hire just any attorney to do this for you. It has to be somebody who knows what they're doing, or else you're going to spend more money fixing what somebody else did than if you would have just spent doing it correctly in the first place. And I'll tell you, my best friend is a family law attorney. She deals with divorces all the time, and even she will not do guardianship. Because I have all these clients I could potentially refer to her, and she says, no, that's not what I do. I can do it, but it's important that you have someone who does these on a regular basis so that they don't mess it up. And then, of course, all the options beyond high school. Once they graduate and your child is set free, set into the wild, released, however you want to say it, then what happens? So we help with a lot of things like that too. Okay, so there is another question, Jennifer. If you want to go to the next slide while you answer this. The types of guardianship and the costs, they're based on the county that you live in, is that correct?
The type is going to be based on the facts of the case, what the proposed ward needs or doesn't need. The costs for filing are going to be county specific, and the attorney ad litem are going to be county specific. But the cost for the attorney is going to depend on what the attorney charges, and that is more than likely going to depend on their years of experience and the complexity of your case, right? So, like I said, if it's uncontested, that's different than if you're going to have to fight it out a little bit more over who's going to have guardianship. So it looks like we have a hand raised.
Yeah, Jessica, if you could put your question in the chat box the best you can, that would be great. This slide, when you get the slides later on today, like I said, you'll get the slide deck and a link to this webinar. If you happen to be, I forgot to say this before, but if you happen to be listening on our podcast and you want a copy of these slides, you can just email us, contact@cpgcares.net, and we'll send you all of these slides. So this one will take you to our website events tab, where we have all of our upcoming webinars listed. Next slide. This is our team. Like I said, we're located just outside of Houston. We work all across Texas and all across the United States. It's 2 husband and wife pairs who are the advisors. And then we have a great support staff who help us take care of other things like paperwork and scheduling and marketing and all of that. And if you'll go to the last slide, Jennifer, this is how to set up a free consultation with us. Everybody who comes to our webinars, you register for the webinar with your email and phone number and name. We reach out to everyone and we ask, do you have any further questions about the webinar that you attended? And would you like to set up your free consultation? So please don't hang up on us when we're trying to call. You know, that slide we just saw, all those cute smiling faces. You don't want to be rude to them. But if you don't want us to call you, the best way to do that is to schedule your own consultation before we get to you, right? So the only thing, like I said, we want to answer your questions first. We learn a little bit about you and your family. We talk about, whatever it is that's really keeping you up at night and try to answer your questions. And then we go over who we are and how we work and how we charge. It's no pressure, low key, and our key goal is to educate and to help. You can follow us on YouTube, Instagram. You can subscribe to our podcast, follow us on Facebook. And again, these are the ways that you can get in touch with us for a free consultation. Jennifer's contact info will also be in the email that you're going to get later on today. So if you'll just leave it on this slide, we'll answer the last few questions that are popping up. What is the reason the guardianship needs a summary each year? What is that annual renewal for the guardianship all about?
So the annual report, it's a report to the court. So the court took away the rights and has, let me back up. When you're going to hearing to get the guardianship, one of the things that you have to do is we call it a prove up. So you have to provide oral testimony that answers a lot of those questions in the earlier slides, the things you have to have in your application. And it answers those questions for the court. Are you an appropriate, are you disqualified from being a guardian? No. Okay, great. Are you an appropriate person for this? Is there someone else? And goes through a lot of different, more intense questions than that. So you prove up, and the court, in hearing that testimony, makes a determination about whether the guardianship should be granted. So they don't want to just grant it and send you on your way and find out 15 years later that things weren't going well. So there are responsibilities of the guardian to the court. And that's what the annual reporting is it's, like I said, in Harris County, they have a form you can get off of their website that goes through everything they want to know. And you file it every year around the date of that your guardianship was granted. It's a way for you to stay in communication with the court. It's a way for them to know that, if you don't file your report, you will be, they will have you come and do a show cause hearing where you have to explain to the court why you didn't. So that relationship with the court doesn't go away. You have responsibilities to your proposed ward, and in filing the report is one of the ways that you meet those responsibilities and let the court know how the ward is doing. Hopefully that answers. So you don't have to renew the guardianship every year, but you have to report annually, and you have to update your letters of guardianship. The letters of guardianship are what you're going to give to your doctors and lawyers and whomever needs to know that you are a guardian of this person. So that's why you have to get new letters every year, but you don't have to renew the guardianship. You just have to report on it every year.
That's fantastic. I see another question here. It's, does my autistic child need to apply for SSI or SSDI when turning 18? Lena, that is more of a question for us at Consolidated Planning Group. We've done other webinars, previous webinars on that. You can find those on our YouTube channel, or you can reach out to us for an answer on that. It depends on your specific situation. But yes, your child can apply for SSI when they turn 18 or SSDI, depending on your family situation. Now, Jennifer, you mentioned during this proof phase that people have to prove that they're not disqualified from being able to be a guardian. Can you tell us what those disqualifiers are for guardianship?
So I, to be completely honest, would have to go back and look it up to give you the specific wording from the code, but it's not, so it's essentially anything that would make you unfit to be a guardian. So if you have borrowed money from the ward, as an example, okay, or if you have a relationship with the ward that's a conflict, if you're in a lawsuit with them over inheritance, then you probably shouldn't be their guardian, right? If you have some criminal convictions, not all. So a lot of times if you have a criminal conviction that doesn't disqualify you, you may still have to explain it to the court. An example would be a DUI from like 10 years ago. Maybe you had one driving while intoxicated, but you haven't had one since. I mean, that's an example, but it's anything that would make you unfit. So it's not, a lot of people think, oh, if I have some sort of a conviction, I can't be a guardian. That's not the case. Some convictions, yes, but you could not be convicted of anything or have any kind of a police record at all and still be disqualified based on your relationship with the ward. So it's another one of those things that's going to be a little more fact specific.
Okay. Well, I don't see any other questions coming through, but I really want to thank everybody for coming out today. Again, thank you to Tawana for hosting us. Thank you, Jennifer, for all this great information. Later on today, you will receive these slides. It'll have Jennifer's contact information, so you can reach out to her. It will have my contact information, or at least Consolidated Planning Group, in case you want to make an appointment with us so that we don't have to call you. Other than that, I hope you have a fantastic day. Thank you again, Tawana and everybody. And if you have questions or comments or concerns, we are always here for you. I think I speak on everybody's behalf when we say that.
Definitely.
Thank you again.
Thank you everyone for attending that supported us here in the Central Texas area presenting these webinars. There's so much knowledge that you can gain from these. So do please look at their YouTube, check out their contents that they have that would be specific to you. So I thank you also for joining us today.
Thank you. Yes, I'm just putting my contact info and the link to our YouTube channel in the chat box one more time so everyone can see that before they hop off. But again, thank you and have a great day. Bye.
Bye, guys.